Good afternoon, everyone. Welcome to the Penn State Law Dairy Quarterly Legal Webinar. This is the topic that we're going to focus on today is geographical indications. This webinar is the fourth webinar that we have had in this series. I would encourage you, if you're interested in viewing the past webinars, they are available on our website that you can go back and take a look at that. Also, our website has all of the program materials for today's webinar, so the PowerPoints that we're using. And additionally, we've prepared a publication, print publication or an electronic publication that really mirrors the content that Brooke Doerr is going to be covering. So those are available on our website. If you go to the events tab that you see at the top, look at specifically at this event, and you can see the resources that we have available. Now, in this the Dairy Quarterly Legal Webinar series, the way that we handle these webinars, we begin with a 20-minute review of developments over the past calendar quarter, and then we move on to a specific topic in the dairy industry that's topical and relevant, and then we conclude with questions and answers. So before we get started, just some of the housekeeping. The webinar is recorded. If you have questions, we would ask that you use the Q&A feature. The chat feature, you can use for any other type of comments that you want to make. For those of you that are getting CLE credits in Pennsylvania, we will be posting a link in the chat, and that's a link to the CLE form. Complete the form, and then we take care of getting those credits for you. There's no charge at all to do that. Now, as a way of verifying attendance that we're required to do for online programs, we're going to be giving you two separate code words during the hour, and this form has a place for you to enter the code words. Okay, so I guess I want to thank our partners. We work with the National Agricultural Law Center at the University of Arkansas, and the program today is made possible by their support. Okay, so today we're going to start off. Brooke Doerr is going to give us a review of the developments over the last quarter. Brooke is a staff attorney here at the Center for Agricultural and Shale Law. And then once Brooke has concluded that, we will move on to a discussion of geographical indications. And our presenter for that portion of the program is Chloe Marie, who is a research specialist here at the center. So Brooke, I will go ahead and turn the program over to you. I will stop sharing, and you can start driving here.
All right, let's see if I can get it working properly. Okay, I'm sharing myself, right? Let's try it again. All right, let's go on there. Let's put this over the screen. Hang on there with me for 1 second. There we go. All right. Now.
It looks good. Just you can hit the slide presentation at the bottom, and then we'll be good to go.
Okay. There we go.
Yep,
Everybody can see it. The big green
yes,
quarterly dairy. All right.
Good.
All right. Okay. Good afternoon, everyone. Again, this is just the runs down. This slide tells you where you can actually click and view some of the prior webinars in this series, and has the link to where the PowerPoints are, just in case you need that. And again, the PowerPoints and everything are up there right now. Okay, I'm going to do the roundup of the second quarter of 2021. And I'll try to be as brief as possible. Those of you who have been part of these before know that that's a difficult task for me. Okay. I'm having the top of my screen cut off by something, and I want to make, oh, there we go. Okay. looks like the headline got very small on this screen. First development that I want to talk about is there were multiple federal milk marketing order reform proposals, which if you attended our last one, you know that we were in the throes of that right at that time. In fact, we, I think, did our last one on April 27th, and this first petition was being publicly discussed and viewed on April 23rd. So we were in the middle of all that with basically what turned out to be two federal order reform proposals that were being discussed in the ag press and nationally. The first one was from National Milk Producers Federation. And again, these were both in response to the price problems and sort of the market distortion that was being created throughout the COVID-19 pandemic and even well into this year. And the negative PPDs, or producer price differentials. I don't want to snow people over with the terminology, but the bottom line was because of unusual class 3 cheese pricing, there was sort of this upside down world where class 1 was actually coming in at lower than class 3, which was skewing the federal pools and how much money was available in the pools, as well as causing all sorts of milk to be depooled, all sorts of class 3 milk to be depooled, which then of course was just aggravating that problem and making it worse, making the class 1 price worse. So the bottom line is, there were these ideas that there would be emergency actions needed from USDA in terms of some reform ideas, and all of it centered on what was called the Class 1 mover, which had been tweaked in the 2018 Farm Bill by legislation instead of by administrative action of the USDA market administrators, as normally would be the case. And as it turned out, well, lo and behold, surprise, surprise, the sort of rash move that was done by statute ended up backfiring. So the bottom line is National Milk's proposal was to just slightly alter the calculation of the Class 1 mover, which, without getting too far into the weeds, essentially is the Class 1 price established after the conclusion of each month's activity. And so that proposal was publicized, made known. It was people were told, or the whole country was told, that National Milk's board of directors had voted to, in fact, file this petition. Well, lo and behold, it didn't get filed. So it's out there. It's out there for people to see. They floated their reform idea, but in the end, despite what press releases said right at the time we were having our last quarterly, they did not end up filing that. They have some information on their website, and you can see, I have a little link here. I have links for everything. So again, my PowerPoints are loaded with links. Just go in there and you can see all kinds of things. The idea is this PowerPoint is meant to be a resource for you, and hit all those links and you'll find all kinds of things. Nice webpage at National Milk is still maintaining, which is now dealing not so much with their content of their petition per se, or their intent with regard to the petition, but more a general examination of the current Class 1 mover calculation problem. There's a nice short 18-minute podcast from National Milk that is talking about their proposal. And so I've got that linked here. Now, the second one was from a group from the Midwest, Wisconsin, Minnesota, Nebraska, and Edge Dairy Cooperative. I think some of those people have signed up perhaps to be here today. We had some in attendance at the last webinar. That was called Class 3 Plus, and they had a completely different idea for essentially a totally new way to calculate the Class 1 price on the federal level. And the bottom line is that one did not get filed also. So now the latest that we've heard from that group, and they are working with Dr. Marian Bozick from the University of Wisconsin, is that Dr. Bozick did a webinar for them on May 21st called Class 1 Price Formula and Ideas for Reform. Very informative, nice webinar. Dr. Bozic is clearly taking a frontline position here out in front of these ideas, and he is under contract to this particular coalition from the sort of the upper Midwest, and is working with them on their reform ideas. So at this point, both ideas are stuck in the mud, so to speak, but they're out there for public discussion. Neither of them went further. All right, next item, we have the U.S. Trade Representative's Office escalating and moving to the next step in the dispute with Canada over the dairy tariff rate quotas. And again, in summary, the Canadians reserved use of certain tariff rate quotas to allow U.S. imports into Canada at more favorable rates. They reserved those strictly for dairy processors, not retailers. And presumably those who negotiated the USMCA thought that those would be reserved for retailers, or that was the general impression, because processors aren't going to buy U.S. dairy products. That's their competition. Retailers are who the U.S. would be interested in exporting to. So the dairy rate or the tariff rate quotas of the USMCA did not have the intended effect. U.S. filed in December of 2020, the beginnings of the process of a dispute, and then the U.S. Trade Representative on May 25th sent the formal letter, and you can see it by hitting this link, to escalate to the process to the establishment of a dispute resolution panel. And this is not being done under the WTO process. These are internal dispute resolution procedures that are in the USMCA, and good thing, because the WTO at this point does not have a working dispute resolution process due to lack of judges. So that's where we're at with regard to that. Most of it at this point will be somewhat confidential. We simply have the public release of the USTR's demand for the actual establishment of the dispute settlement panel. Next, there was a federal lawsuit that challenged the dairy guidelines in late April. It was filed by a group of physicians from the West Coast, and it was filed in the Northern District of California. It's a little bit novel and a little bit, headline centered, perhaps headline, designed to grab headlines, let's say. It essentially alleges that the 2020 dietary guidelines, which were of course just issued at the end of last year, are not based on current scientific and medical knowledge because they recommend and they're not disclosing the ill effects of consumption of meat and dairy. So you can see where that's coming from. It's obviously to make a point as opposed to maybe a realistic idea that the dairy guidelines are somehow going to be invalidated. They also allege that the USDA representatives who composed the dairy guidelines help compose them, have a conflict of interest because they also have statutory duties to help develop and expand dairy markets. So that's novel and interesting, and this is more an intellectual exercise perhaps than something that's going to get accomplished by litigation, but it's out there. Latest is really there are the very preliminaries with the status conference in September. Next development was the Pennsylvania move on the dairy producer termination notice requirement from 28 days to 90 days by regulation. When we had our last webinar, this was in its process, but now we've moved much further to the point where it was submitted to IRC. IRC approved it on June 17. For those who are not Pennsylvania residents, IRC is our sort of super body that reviews regulations as an independent reviewer and has the power to, in fact, disapprove regulations. So the bottom line is it stands for Independent Regulatory Review Commission. We do have many out-of-staters here. IRC approved them. Next step in Pennsylvania is they go to the Attorney General just for form and legality, and they are just about in there. In fact, the time should be up for the PA Attorney General to get back to the Milk Marketing Board. I don't know if we have Doug Eberly or somebody on board here who might be able to give us an update as to whether there's any reason why these regulations are not completely ready to be published as final. Interesting little tidbit that I caught at a yard sale one day. I picked up an old copy of Pennsylvania Farmer from 1978 sitting on a table. with a big stack of them, which I have over on my table here. 43 years ago, they were talking about moving the notice of termination of a producer under the PMMB, or the Pennsylvania Milk Marketing Board regulations, from 21 days to 60 days. Well, 43 years ago, somebody eventually got it moved to 28 days. But other than that, it took 43 years for us to get over the 28-day hump. And now we are finally moving to 90 days. So it's one of those eternal issues that, boy, it's been a long time coming, that's for sure. Next, the Milk Marketing Board, the Pennsylvania Milk Marketing Board, did issue some directives with regard to making sure that it's clear that milk donations and discounted milk that are sent through essentially the charitable food system are not subject to PMMB pricing regulations. However, I put in the middle of this, it's interesting because this does not apply to TFAP milk that is purchased by the federal government. That is still subject to PMMB pricing regulations, as I understand it. And also there's this $400 million dairy donation program, which was part of some of the sort of pandemic related legislation that occurred over the last 6 to 9 months. And there's $400 million to essentially pay for the costs of for processors in donating milk to the charitable food system. That's not really addressed in the PMMB's pricing bulletin. Might be something that needs to get discussed at some point in the future. Next development is the EU flirted briefly with some very restrictive legislative language from the European Parliament on the use of dairy terms for non-dairy products. And there was a very restrictive piece of legislation that they were considering, but ultimately it was withdrawn after objections from various interests, aligned with the non-dairy products. And so you can read, clicking these links, you can read the letter that opposed it, and essentially that appears to be why, in fact, it was withdrawn. I've just included the actual text of the amendment. The reason why this is important is simply that if you take a look at the text of this and you look at it, this was extremely restrictive, way, we obviously know that the FDA has done nothing yet, but this was an attempt to really do something very significant, which failed, but there's a lesson there and there's some language to study. So that occurred in the last quarter. Next, we had a federal petition that has been pending for a number of years, filed by Mark McAfee from California, who may be well known to some, and also the Farm to Consumer Legal Defense Fund. And they were trying to get unpasteurized butter, in other words, raw butter made from raw milk, to be approved for interstate commerce by essentially alleging that the federal government didn't have the authority to prohibit it. That ultimately was defeated in the U.S. District Court for the District of Columbia. There has been an appeal filed from the denial of that petition, and that is now pending at the D.C. Circuit Court of Appeals. Don't know if that's another sort of litigation to prove a point, or whether there's really a realistic idea that it might go somewhere. But that is a development that happened recently. I think the original petition was from 2019. So it was pending for a couple of years until it was finally decided by USDA and then went to the district court. Okay, next development. FDA basically rescinded and replaced all of their standards of identity with regard to yogurt products. And this was apparently a long overdue improvement on what was apparently a very confusing set of standards of identity for yogurts that made kinds of distinctions between non-fat and low-fat yogurt that were just not workable in today's world, as well as some of the ingredients in yogurt and some other terminology that's used on yogurt labeling. The bottom line is some people have viewed this as a nice positive, that maybe it starts to begin to provide a little more lubrication to the idea that FDA standards of identity with regard to milk products will become tougher, so that non-dairy beverages that are using the words like milk or other non-dairy things using words like yogurt might end up, finally being addressed in some way. One of the things that I pulled out of this was that now you see these little notes on yogurt about containing live or active cultures. It is optional under these regs, which are not quite going to be in effect until 2024 in their final form. It's optional to say it contains live or active yogurt, active cultures. However, it's mandatory that you must say it does not contain live or active cultures if in fact that's the case. So it's a little bit backwards from the kind of things that some you might automatically assume in the area of food labeling. And I think the yogurt industry is very happy with this. Long over. In fact, the petitioning organization was something like the Dairy Yogurt Association, who has long since gone under and been out of business. I believe this regulation was proposed some astronomical number of years ago, like perhaps 15. All right, next on the basic labeling front, Pennsylvania did something quite forward-thinking with regard to instituting the best buy or sell by milk labeling system that's now in place. And if you're not from Pennsylvania, this is worth taking a look at in some detail and understanding what's going on. Essentially, now a processor in Pennsylvania has an option to use a sell by date or a best by date. Both of them must be no more than 17 days after pasteurization, and both of them either are enforceable in the sense that sales are prohibited after that 17-day time period. However, individual processors can now petition the Pennsylvania Department of Agriculture for leeway to establish something longer than 17 days if they wish, with proper supporting documentation, and they will be follow up and they'll have to comply with their proof that they provided to the department to gain the approval that essentially bacterial counts remain within the regulatory limits for whatever day they would like to be approved to label. So they could go with 21 days or some other date if they can prove it, and if they maintain their process and proof that that's in fact, that the product is remaining within the bacterial limits. So it's giving more flexibility. As people always say, these deadlines are more a quality issue rather than a food safety issue at this day and age with pasteurization being what it is. Okay, that's the extent of my presentation. I have many other extra slides in here, so get yourself a copy of the PowerPoint, because there's a lot of other very interesting information that I compile into these slide decks. It's just that we know we're never going to get to them all. So with that, I will end my sharing, Ross, and turn it back to you.
Okay, thanks a lot, Brooke. And just to highlight, these PowerPoints are available on our website on the events page. And in addition to Brooke's PowerPoint, we've created a more traditional publication that has essentially the same content, just in a different format. Okay, so Chloe, if you could advance the next slide. So we mentioned the code words that we're going to be providing for those of you getting Pennsylvania CLE. So again, the first code word. Oops, we've lost the.
Sorry, yes, I'm just gonna.
Yeah, lost the PowerPoint. The first code word is cheese. So for the Pennsylvania attorneys looking for CLE credit, the first code word is cheese. Okay, so our topic that we're going to spend the rest of today talking about is geographical indications. And I guess the first question is, what are geographical indications? And really it's as simple as there's an indicator, a name, a name or on the packaging that's associated with a particular product. And that name or that sign on the packaging indicates that product came from a particular geographic location. And also there's some connection between that geographic location and the product. There's got to be a link there. And so if you think about the product champagne, what is champagne? Well, champagne is a beverage that is produced and comes from grapes that were grown in a particular region of France. If you have grapes that are grown and go through the same process from another location, that can't be called champagne because the product is associated with a particular geographic location. Another example would be Vidalia onions, which I would think many of you are familiar with. Vidalia onions are a sweet onion that is grown in a particular geographic location in Georgia. So someone who grows a sweet onion outside of that particular geographic area, they can't call those onions Vidalia onions because Vidalia onions must be grown in that particular location where the soil has a low sulfur content, which makes the onions sweet. So with the geographical indications, you have that name or something else on the packaging that has a connection that connects the product to that particular geographic location. And so I think then the next question that just to set the stage for the rest of our presentation, why is this important in the dairy industry? And if you think about all of the place names on various cheese products, you get the answer that cheese names often have a geographic location in that name. And the extent to which that particular name, that particular geographic identifier is given legal recognition has a large impact on international trade of those cheese products. So with that, I'm going to kind of end my 2-minute introduction, and I want to introduce Chloe Marie, who is a research specialist with the Center for Agricultural and Shale Law. Chloe received legal degrees from the University of Paris, and she received an LL.M. degree from Penn State Law in 2015. She has performed a lot of research on various energy law topics, and over the past few years, she has kind of added to her portfolio a number of food and agricultural topics as well. So Chloe, we're pleased to have you with us today to talk about geographical indications. And I guess could you start by just telling us about some of the international law that governs geographical indications?
Yes, so thank you, Russ. So first, I would like to thank everyone attending our webinar today. I do hope you will find it useful. All right, so protection of geographical indications in the international market is generally ensured through international agreements. And one important international agreement protecting GIs is the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property, also referred to as the TRIPS agreement. And this agreement applies to all WTO members, including the United States. So the TRIPS agreement provides basic principles for the protection of geographical indications under Article 22. It first provides a definition of what are geographical indications, and they are described as indicators which identify a good as originating in the territory of a member or a region or locality in that territory, or a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. And Article 22 also requires each member of the agreement to provide legal protection to geographical indications against usurpation. The language in Article 22, however, is not specific with regard to how members of the agreement should choose to assure such protection. Another article, Article 24, provides some exceptions to the protection of geographical indications. It simply says that members of the agreement do not have to protect geographical indications if the names they do protect became a generic term in their countries. And another exception is that the protection of geographical indications cannot conflict with trademark rights that have been previously acquired in good faith. So WTO members must abide by the terms of the TRIPS agreement, but it is up to them to decide how they want to ensure protection of geographical indications. So generally either through specifically crafted legislation or trademark system.
And Chloe, since it's up to each country to provide the specifics of how they're going to provide protection, how do the United States and the European Union member states provide protections to geographical indications?
So in the US, GIs are protected as trademarks under Section 4 of the Trademark Act of 1946. And the US Patent and Trademark Office is the agency in charge of regulating GIs and allows the registration of GIs as a certification or collective marks. So a certification mark is a type of trademark. It may take the form of a name, sign, or logo on a product packaging, and it certifies that the product meets specified standards. It shows to consumers that a product comes from a specific geographical area and that the product meets certain standards with respect to quality, mode of manufacture, etc. So that is the primary function of a certification mark, to distinguish those products that comply with some specific requirements or standards which have been certified by the mark's owner. And another important point is that the owner of a certification mark is usually a company, and it is the only one who can exercise legitimate control over the use of the mark. It is also the only one who can determine the standards each producer must comply with in order to use the mark on their products. And only authorized users may use the certification mark. So here are actually some examples of foreign geographical indications that were protected under the US trademark system as certification marks. So I believe most of you already know Roquefort. Roquefort is a kind of blue cheese with a very sharp flavor, very popular in my home country. And it is produced in the natural caves of the community of Roquefort in the department of Aveyron. So Roquefort was first registered in the 50s, and its registration as a certification mark was renewed in March 2013 and is good to go until 2023. And then we have Parmigiano Reggiano, another popular cheese, this time from Italy. And its registration as a certification mark was renewed in July 2018 and is good to go until 2028. And its owner is the Consorzio del Formaggio Parmigiano Reggiano. So now a collective mark is another type of trademark, and it can also take the form of a sign, logo, word, or group of words. It indicates membership in a collective entity, for example, a union, association, or other type of organization, and distinguishes the geographical origin, quality of manufacturing of a product. It serves to differentiate certain products from those of non-members. Very important is that a collective mark implies that the product supplied by members of a collective entity conform to the specified standards set by the collective entity. So unlike a certification mark, a collective mark cannot be owned by one company or producer. It must be owned by the collective entity, and it can only be used for the benefit of its members. The collective group or entity does not itself sell the products, but is allowed to advertise the mark and the products that were sold by its members under the mark. So if some of you here have heard or tasted this delicious pasta dish called cacio e pepe, you may be familiar with the cheese pecorino romano, which is the main ingredient of this dish. Pecorino cheese is a collective mark. The Consortium for the Protection of Pecorino Romano first filed the collective mark with the USPTO in the 80s, and it consists of the Italian words pecorino romano, which means Roman cheese made from sheep milk with the design of a sheep's head within an inclined square. And only members of this consortium can use this collective mark.
Okay, so Chloe, so the US system is based on this trademark framework with individual companies and organizations having the right to use or control these the product names. How does the system in the European Union differ from the US system?
So the European GI system is more protective than the US trademark system. Main reason is that most of EU member states are part of the Lisbon Agreement and the Geneva Act, which provide a higher level of protection to GIs and is wider in scope than the TRIPS agreements. And unlike the United States, the European Union does not protect GIs through a trademark system, but through specific regulations that have been adopted by the European Parliament and Council, and that have a direct effect on the laws of its 27 member states. So the current European legal framework for GIs separates GIs into two categories. The first category is protected designation of origin, PDO, and the second category being protected geographical indication, PGI. So a protected designation of origin applies to agricultural products and foodstuff whose quality or characteristic is essentially or exclusively due to a particular geographic environment and its natural and human factors. And every step of the production, processing, and preparation process must take place in the same geographical area. So a PGI also applies to agricultural products and foodstuff whose quality, characteristic, and reputation this time is essentially attributable to the geographical area and where at least one of the stages of production, processing, or preparation takes place in the area. So the main difference between a PDO and a PGI lies in the fact that a PDO is more restrictive because it must be produced, transformed, and prepared in one geographical area, while a PGI can be produced, transformed, or prepared in different areas. So even though GIs in Europe may seem similar to US trademarks in the sense that they both identify the origin of a product, they do differ, however, in many ways.
And could you talk a little bit more about those differences?
So a GI identifies a good as originating from a specific place. On the other hand, a trademark identifies a good as originating from a particular company. Another difference is that a trademark is a private right and it belongs to the company that created the trademark, while a GI is a collective right and it belongs to any producer producing a good in the region identified by the geographical indication. The GI is closely linked to a specific geographical area, and as I've just mentioned, a GI may be used by any producer as long as production is located in the area of origin and that the product is produced according to specified standards. A GI cannot be used by someone located outside that area. Trademarks, on the contrary, can be licensed to anyone, wherever they may be in the world, because what matters is that a trademark is linked to a particular company, not to a specific geographical area.
Okay, Chloe, now that we've discussed that legal frameworks within the United States and the European Union, let's shift gears to talk a little bit about economics and trade. I guess before we do that, we have the second code word of trademark. So again, for the Pennsylvania attorneys looking for CLE, the second code word is trademark. Okay, so shifting gears from the legal to the economics and the trade. You know, I think GIs are generally viewed as being a bigger topic or a more important topic in Europe than in the United States, and they're really viewed that way throughout market participants. You know, from farm to fork or throughout that entire farm to fork chain. Can you talk a little bit about the European viewpoint on the importance of GIs? Of
course. So GIs are very important to the EU. And you know, the other day I was listening to a webinar was stated by the European Commission about GIs, and what struck me was their own saying that the EU is obsessed with the concept of GIs, and it appears that this is what the US mostly reproached the EU to be in dealing with GIs. And the main reasons why Europe is not letting go of GIs are both cultural and economic. So the European Commission explained that traditional and high quality products are what European citizens and consumers are looking for. And that is why there is an increasing demand for ag products or foodstuff with specific characteristic, especially those linked to their places of origin. Some now even refer to gastronationalism when talking about European GIs, and that Europeans are very attached to the preservation of their local traditions in terms of food production, especially in the current context of globalization. The European Union also has an economic interest in protecting these local traditions. According to the Commission, there is a real advantage for producers to benefit from a system where the name of a product is reserved to certain products that meet specific standards, because it allows for a better price on the markets, and on average around twice the price of the conventional product, as well as a better division of the added value along the food chain. They also say that consumers can benefit from GIs because they receive a guarantee on the origin, quality, and authenticity of a product, and because this guarantee is ensured by controls on production site and on the market. And finally, GIs benefit the society in general because their protection help secure jobs in local areas, sometimes remote areas, and maintain economic activities in rural communities. They also say that GIs encourage the preservation of biodiversity and sustainable agriculture, as well as local and traditional methods, and it also promotes tourism in those areas.
So that's a helpful description. Now, when you translate all of those benefits into financial terms, what's the total monetary impact to the European Union?
So in February last year, the European Commission actually published a very interesting study on the economic value of GIs in Europe. And they reported that the total sales value of GIs was estimated at approximately 75 billion euros in 2017, and that ag products and foodstuff represented about 35% of this value. It was also reported that the total sale value of GIs has been steadily increasing since 2010. The study shows that the global value of GIs increased by 37% from 2010 to 2017, which equal to an amount of around 20 billion euros. And this increase is mostly due to the registration of new GIs in France and Italy. The study also showed that in 2017, the sales and exports of products bearing GIs to non-EU countries represented approximately 17 billion euros. And what I found interesting is that the products exported to non-EU countries have their origin primarily in 3 countries, France, Italy, and the United Kingdom. Just please note here that when the study was conducted, the UK was still a member of the EU. So their origin primarily comes from France, Italy, and the UK, and that the concerned exported products bearing GIs were Champagne and Cognac from France, Grana Padano, Parmigiano Reggiano, and Prosecco from Italy, and Scotch whiskey from the UK. I actually don't know, but Grana Padano is a type of cheese, just in case you may have wondered, like me. And another interesting point is that cheeses in 2017 accounted for more than 1/3 of the total EU sales value for agri-food products with GIs. And as you can see on this graph, the sales of GI labeled cheeses have increased by 43% since 2010 and contributed the most to the growth of the ag food sector with 32%. So Italy, Germany, and France together gathered 65% of the total sales value in 2017, with 47% of the total number of GIs registered. And then they were followed by the UK, Spain, and the Netherlands which accounted around 24% of the sales value in 2017, with 20% of GIs registered.
So, Chloe, with all of the emphasis on the protection of GIs relating to cheese, the EU's more restrictive approach has a big impact on dairy trade, both in terms of direct trade between the US and the EU, as well as in trade between the US and other trading partners who also trade with the EU. And a lot of these trade issues revolve around the determination of what is considered to be a generic term in a product name. Can you elaborate a little bit more on these overall trade issues, as well as what is meant by the term generic?
Sure. So I believe it is safe to say that over the years, the United States, or at least the US food industry, has not been so thrilled about the way the European Union decided to protect geographical indications. Some called out the EU for resorting to economic and trade protectionism, therefore creating trade and market barriers and affecting its trade partners, and that European GI policies were harmful to US food producers and exporters. So it is my understanding, though, that the problem does not lie with the fact that the EU and the US have different approaches to regulate and protect GIs, or how they each decide to register or enforce GIs, for that matter. But as Ross just stated, the real issue has to do with the scope of protection that is granted to GIs, and the fact that the European Union is using GIs to register names that have already entered the public domain and are generic terms according to the US. So as a little background, a generic term is a common name referring to the nature or class of a product and must be understood as such by the public. Anyone can use a generic term because it has no distinctiveness. And that even applies if the generic name relates to a specific geographical area. For example, in the US, Brie, Ricotta, or Saint-Paulin are cheese names that are generic terms. And their use in the United States could be at risk because of the European interpretation of GIs. But really the issue for US food producers is that some of these names have been used for generations and have become common names for certain types of food, like cheddar or mozzarella. And these common names have also become part of brand names, like, for example, Tillamook medium cheddar or Sargento shredded mozzarella. And if a generic term becomes a GI, it means that US food producers would have to change their entire branding name and strategy, which could be economically harmful to them, especially for small producing companies. Actually, on this point, in late 2018, a report prepared for the US Dairy Export Council found that GI restrictions, if they were to be implemented in the US, would significantly limit the use of common cheese names and would dramatically reduce consumption of US produced cheese subjected to GI restrictions. It also would reduce demand for US cheese exports, while US imports of European GI labeled cheeses would increase by 30%.
And how does that translate into reduced product volume or revenue for US producers?
So here are some of the highlights which show the adverse effect of GI restrictions on common cheese names in the US dairy sector. So the report says that the total US milk equivalent consumption would fall between 56 billion and 136 billion pounds. That farm gate margins would remain significantly below break-even levels for at least 7 years, forcing greater liquidation of the US dairy herd. The loss in herd size would range between 460,000 to 740,000 head due to the implications of GI restrictions on common cheese terms in the US. And finally, farm revenue losses would continue to increase, reaching a cumulative $71.8 billion in lost revenue over 10 years. According to this report, this adverse effects also would be felt beyond the cheese manufacturing sector. Industries such as butter and cream manufacturing facilities and whole-skim milk powder manufacturing would benefit from lower milk prices, but due to the expected high volume of milk moving from cheese production into alternative products, they would see prices fall for their products.
Now, Chloe, I referenced earlier about indirect trading impacts. Could you provide a little more detail on that topic?
Yes, so another major problem for the US is that the EU is trying to impose a GI system in other countries through bilateral agreements, therefore making it even more complicated for the United States when engaging in foreign trade deals. The US see European GI restrictions negotiated in bilateral agreements as a conscious move from the European Union to repossess the use of these common names and prevent other food producers from marketing their products using these common food names. These bilateral agreements could have the impact of restricting the future sale of US exported products using such common names to these other countries. So the issue between the US and the European Union over GIs protection is really not about the fact that GIs are intellectual property rights, but is about the European Union's constant effort to restrict the use of common names in the US that have been used as such for generations, and the inevitable disruption to foreign trade activity.
Okay, thank you, Chloe, very much. That has been very informative. If anyone has any questions, please input them into the Q&A feature, and we'll take questions. We'll take questions at this time for either Chloe or Brooke on the geographical indications or on some of the current recent developments. We have a question here. Are there currently instances where GI treatment is being pursued in the European Union for food products that are considered to be generic in the United States?
Good question. I don't know about that, but I'll definitely take a look, but I'm not sure. Yeah.
And so, yeah, so we have the pursuit in the European Union, considered to be generic in the US. Okay, so John, we can get back with you, or we can post that that answer. Are there any other questions that someone has? And did we have some in the chat earlier on?
No, Ross, I did check in there. There wasn't anything in there.
Okay, I thought there was one that, as far as ideas why that petition hadn't been filed.
Oh, really? Well, I can address that. Let's just, oh yeah, here we go. You're right. Any idea? Well, no, I don't know for sure why the national milk petition wasn't filed, other than I know that they had a qualification on there that they were trying to submit it as that it was going to be limited to like just the question that they're asking, because they didn't want the scope of any hearing process to start getting bogged down and encompassing other questions. But and I think maybe they were talked away from filing at all because of the prospect that it would end up encompassing other things that they didn't want it to encompass. Because I don't know that USDA is going to be able to limit it based on their existing administrative, sort of parameters. So I think that's one of them. And I think that the group from the sort of the northern Midwest, they came along after. They were about 2 weeks or so behind National Milk in terms of their announcement of what they were going to do and everything. And I think they probably figured, well, if National Milk isn't doing it, then we probably all ought to hold off until some future time. And of course, the PPD problems and sort of the price inversion, shall we say, did start to get better over time, although they didn't get better immediately, nor are things completely back to normal. So it's hard to know, really. I am a little amazed that, with all of the attention that was paid towards the idea of, oh yes, we're going to go to USDA, file these emergency petitions, and get all this immediate action, kind of amazed that it dropped so fast.
Okay, thank you. And I see we had another question, and Chloe, I see you're typing an answer to that. So
I can answer that. Okay,
so the question was, and I guess before we get to the question, we do have a poll that we've posted. We would certainly welcome your input in terms of topics that you would like to see in future dairy legal webinars. So the question, the USMCA, of course, that's the US, Mexico, and Canada agreement, included side letters intended to preserve the rights of use for US cheese producers and prior users. Is this going to be a template going forward for new trade agreements?
I actually would say yes. Yeah, because I mean, I do think this is a move from the US to prevent further issues in dealing with foreign trade. I believe that the US here is also trying to prevent Mexico, I think it was, from imposing their GI system into other countries. So that's definitely a protective move, yes.
And Brooke, do you have anything to add there? I know you had been looking at that issue as well.
Yeah, I think Chloe covered it, yep.
Okay, so are there any other questions? We're approaching the end of our hour. I know there had been some, or there are some proposals to change the EU system, and Chloe, I don't know if you want to get into that in the 2 or 3 minutes that actually we have another. Let's go ahead and take this other question. Is the EU trying to stop and restrict the United States free market system by using EU GIs that are more restrictive?
It's a sensitive question in a sense that I don't think that the EU is directly trying to stop and restrict the US market, but indirectly, yes, they want to, especially, as I was saying, GIs bring a lot of money to Europe. So obviously they want to have some sort of a control over what's happening in other countries. But yeah, that's a sensitive question, and yeah, I would rather say not directly.
And I think some of it goes to the way that people in Europe view GIs just at a general level. They're much more protective of that name, of the name of the product that's being produced. So I think they're as Chloe mentioned, some of the economic but also cultural desire to kind of protect the use of a particular word, of a particular place name. And so I think that is really part of the motivation for them to retain control over that place name when it's used in association with a product. We also have a question for you, Brooke. Why are negative PPDs referred as a problem? My understanding is that they happened because cheese prices were exceptionally high.
Yeah, and what that actually caused, number one, was the depooling of milk that was going to class 3 cheese, meaning that quantity of milk, because the processors wanted to essentially get out from under those extremely, the calculation that was producing the really high class 3 cheese price, they would depool their cheese or their class 3 milk, taking it out of the pool, which then deprived the pool of money to distribute to all producers in that federal market order pool, which meant that everybody else's price went down, and even the class 3 people weren't getting the benefit of the high pricing once their milk was depooled. So it was actually causing processors to react in such a way that was throwing off the entire federal pricing system, and no one was getting the benefit of those extremely high cheese prices because the milk was getting depooled. That's the easiest way, I suppose, to say it. And I see that somebody from National Milk just posted a understanding PPD's link there, which is, there's all kinds of great information that they have put together out there to understand.
Okay, yeah, and we have reached the 1 o'clock time, and so I want to thank Chloe and Brooke for presenting today. I want to thank all of you for attending. Our next Dairy Quarterly Legal webinar will be conducted in October. So we will send you all more details on that program as we get closer to that date. So once again, thank you very much for participating today.